Good morning, everyone, and welcome to our second seminar for in-house counsel and in-house teams. I hope everyone is looking forward to a diverse session on practical tools for in-house counsel, which is scheduled to run for around an hour. To start with a few introductions, I'm Mohammed Akil Latif, head of our corporate and commercial departments, and will be hosting today. Speaking will be, and backed by popular demand, Richard Meehan from the commercial team on key legal negotiation issues in IT contracts, followed by Richard Wolf from Insolvency and Restructuring, who will look at addressing your business's insolvency concerns relating to clients, customers, and suppliers. And finishing with Chris Moss and Jonathan Garner from our corporate team, going into detail on a corporate governance and compliance update, everyone's favourite topic. As always, you can ask questions via the Zoom Q&A function. Whilst we may not get to them live, we'll certainly follow up with responses after the seminar. With this being online, there isn't much housekeeping to do, other than letting you know that we'll be recording this seminar. To save you having to make notes as we go along, we'll email a link to the video along with the slides so you can rewatch the seminar at your leisure. Before we start properly with the speakers, just a quick Myson plug. Having supported in-house teams for many years and a number of our partners and solicitors having been in-house, we do understand the challenges and pressures you face as in-house counsel. As always, we'll be happy to help in a manner that works best for you and the business. Now to the speakers, starting with and handing you over to Richard Meehan.
Thank you, Akil. For this part of today's session, I'll be discussing some commonly negotiated issues in IT contracts. IT contracts are interesting for a range of reasons. Their subject matter is often complex, and the solution may be expensive or business critical, or often both. The contracts generally have to focus on the product itself, but also have to give consideration to the services that go alongside the product in terms of development, implementation, and maintenance. And also, IT contracts are probably some of the more likely types of commercial contract to find their way out of the drawer after they've been signed, with the parties needing occasion to refer back to consult the contract to understand how user acceptance testing regimes are designed to work or service levels. The four topics I'll discuss reflect these themes. I'll start by looking at how an IT contract goes about describing the solution. I'll talk about the function of the specification, how it fits into the contract as a whole, and the role that the lawyer can take in developing and negotiating its content. The next topic is Agile methodology. Since Agile methodology will often be proposed by the supplier, for today's session I'm going to look at it from the customer's perspective and think about some points of potential negotiation. I'll then discuss service level agreements, SLAs, and some of the challenges involved in ensuring that these actually work in practice rather than just looking good in the contract. And finally, I'll conclude, as we're contractually obliged to nowadays, with some thoughts on artificial intelligence and some negotiation points to consider when the solution will involve AI. Part of the challenge with IT contracts undoubtedly stems from the fact that the people who know how to build IT solutions are generally not the people who are writing the contracts. And indeed, there'll quite often be several layers of communication in between. The challenge is also a virtue to a degree because the end users of the solutions are not themselves necessarily IT specialists, and the contract has to work for them too. And the issue really comes to a head most clearly when the contract has to describe the specific solution. The purpose of describing the solution from a contractual perspective is to achieve certainty between the parties about what the service will actually deliver. So what has to be delivered in order for the supplier to have satisfied their primary obligations in the contract. The description should therefore have both a functional aspect, what will the solution do from the user's perspective, and a technical aspect, how in terms of the infrastructure and the software will it achieve that performance. It should also, where there's a possibility of dispute on any of these points, clarify what the solution will not do and set out any conditions necessary for it to function. So from a negotiation perspective, the lawyer for the supplier will sometimes be faced with the issue that IT solutions are sold in poetry and then have to be delivered in prose. So the lawyer for the supplier may want to ensure that the natural tendency of their colleagues to emphasize the all-singing, all-dancing nature of the solution gets reined in when it comes to what actually goes into the contract. The customer, on the other hand, will want to ensure that any relevant claims regarding system performance that were made during the sales process do get included in the contract. The customer will also want to ensure that the contract requires the system to meet the customer's functional requirements, whereas the supplier will have an interest in instead limiting their delivery obligations to the technical specification. And then, since the contract will often end up recording both the customer's requirements and the supplier's specification, it becomes important for both of the parties to think, when they're drafting the operative clauses, how those clauses will interact with the description of the solution that's being included, and how aspects such as user acceptance testing, warranties, and service level obligations work both in respect of the functional requirements and the technical specification. Over the next couple of slides, I'll look at two areas where the main operative terms of the agreement interact with the description of the service of the solution, thinking about warranties given by the supplier and also about customer dependencies. The wording we have on this slide will be a fairly vanilla warranty in respect of compliance of a piece of software with its specification. So beyond the normal tussle over whether this kind of performance warranty also needs to be a representation, the key elements of this clause is a requirement for the software to perform in accordance with its specification and to do so for a specified period of time. Now, if the specification has incorporated the customer's initial list of functional requirements, it will be difficult for the supplier to argue that the warranty is satisfied if, at any point during that time, the software is not allowing the user to do any of the things which the list of user requirements indicate that it should be able to do. So, the supplier should aim to ensure that the specification included in the contract expressly stated any conditions or limitations on the functionality that will be achieved in practice, especially where these may conflict with the customer's expectations. The specification allows the parties to agree what the solution will and will not do. It's also important for the parties to be clear about any responsibilities which the customer will need to fulfill in order to allow the supplier to deliver the solution. So the clause on screen picks up on the concept of customer dependencies in a particular scenario. So what we have here is thinking about delivery of the solution. But the same concept is relevant to many different aspects of the arrangements. The clause on screen takes a fairly generic approach to considering customer dependencies during that delivery phase. Essentially, it's saying that the supplier is dependent on the customer and not to change their mind about timescales. So that is not to request a delay, but also dependent on them not to do anything that might cause delay, and even not fail to do anything that, by its failure, might cause delay, acts or omissions. Now, from the customer's perspective, this reference to omissions should raise the question of what their positive obligations are in terms of providing support during this phase. What kind of omissions should the supplier be able to rely on to say it gets relief from its own obligations? It's helpful for both parties to have clarity on that point, particularly thinking about it from the supplier's perspective, if they want to attempt to use the benefits of the clause to justify a change in the contract price, as the wording in blue at the end of the clause would allow it to do. It's also in both parties' interest for the contract to be as clear as possible about the customer dependencies as it is, and to be as clear about those as it is about the specification, since this may help to avoid time-consuming and costly disputes about who is responsible for a delay in implementation or a failure in the system. Our next two topics in this part of the talk look in more detail at the implementation phase of an IT project, and then look at how the parties can manage system failures through the use of a service-level agreement. One of the fundamental choices for the parties at the outset of a software development arrangement is to decide on the development methodology that will be adopted. That choice is normally driven by the supplier, and a relatively common model that they may propose is Agile. Over the next couple of slides, we'll consider some of the areas where the customer may wish to negotiate when Agile methodology is going to be used. Just to set it in context, though, at a high level, Agile development is typically viewed as a counterpoint to the more traditional method of development, which is sometimes described as a waterfall development. Where the traditional method would be based on a predetermined series of development stages applicable to the solution as a whole, each of which has to be fully completed before the solution can cascade down to the next stage in the waterfall. Agile, on the other hand, is designed to allow greater flexibility. In particular, it envisages that planning, development, and delivery phases can happen simultaneously in respect of different elements of the solution. And it also is expected that it will be an iterative process, and there'll be a feedback loop and continuous improvement. The theory of these methodologies is helpful to bear in mind, but the contract needs to reflect the detail of how the parties actually intend to operate in practice. The same issues discussed in the previous section regarding clarity over the specification and customer dependencies remain important. From the customer perspective, for example, using Agile should not have to mean adopting a wait-and-see approach to the functional specification of the finished product. It's important for the user stories, which are expressed by the customer at the outset. It's important for them to have sufficient clarity to allow the parties to refer to them later when asking the question of whether the delivered solution actually met the customer requirements. Adopting Agile methodology certainly has benefits for the customer in terms of flexibility of delivery and the ability to provide ongoing input and feedback, which should mean that what is eventually delivered more closely reflects their requirements than if the customer had a more hands-off approach. However, this does mean that Agile places more onus on the customer to remain involved in the process. And so from the perspective of customer dependencies, the customer should ensure that the expectations in terms of personnel, resource and availability are clearly stated in the contract. So there are therefore risks, but also opportunities for the customer in accepting the use of Agile methodology. In the next slide, I'll discuss an example of how negotiation at the outset may allow the customer to mitigate some of those risks. A clause on this slide showcases some of the typical language of Agile and also gives an indication of the mindset underlying it. The principle here, as you scan through it, is that there is flexibility for the parties to decide what development work gets done in what order. That is, what product backlog item is worked on next. And that to get to inform that decision, the supplier is going to estimate how much resource, how many person hours expressed in resource points each of the different potential work streams will require. The clause highlights the relative sophistication of this model, which reflects the reality of software development. As it becomes clearer what effort will be required to complete a particular development objective, for example, the number of resource points can be adjusted, allowing the parties to plan more accurately their next steps in order to achieve the customer's priorities. However, the ability to reallocate resource on the fly to reflect changing priorities also has the same drawback for the customer that any time and materials-based pricing model has, i.e. uncertainty over the final cost. The customer will have visibility at a more granular level over where the time has been spent, and will have input and ownership over how the supplier's effort is applied, but that may be of very limited comfort if the solution is still not doing what the customer wants it to do within the customer's expected timeframes. So, introducing budgets and potentially also introducing key milestones and staged payment principles, while not necessarily in keeping with strict Agile theory, can help to create a hybrid model and can create an incentive for the supplier to steer the project along the customer's desired channels, and it can increase the customer's price certainty. Once the solution has been developed and accepted, the next focus of attention for the contract is how problems that might arise during the operational life of the system are managed. Service level agreements are designed to allow these issues to be resolved efficiently and in a manner which both parties can accept, and time spent in negotiating them can bear fruit later. In terms of commonly negotiated elements of IT contracts, service level agreement would be fairly high in the family fortunes style survey. It's, of course, of key interest to the customer to understand what quality of service the supplier is offering, and it's quite easy to compare the number of nines that a supplier is prepared to offer in respect of availability from one supplier to another. It gets called the service level agreement, reflecting that level of importance, even though it's often just one element of the wider contract. Thinking about the SLA as though it were independent from the wider contract, though, may be a mistake. It has to align, in particular, with elements such as the specification. So it's important from the customer's perspective that the supplier's obligation to deliver a solution which satisfies the specification is not undercut by an SLA, which only requires the supplier to deliver the solution at limited times or to a different standard, or only subject to the performance by the customer of customer dependencies that don't appear anywhere else in the contract. Any of those inconsistencies can arise if the SLA is treated entirely independently. Another key issue to consider with SLAs is the treatment of remedies. A key rationale for using the SLA in the first place is often to provide certainty over those remedies, and setting appropriate levels for the service credits themselves is a science or an art in itself. But from the legal perspective, it's crucial to assess how the remedies specified in the SLA interact with the general principles of liability in the agreement as a whole. So a commonly negotiated point is whether the service credits should be an exclusive remedy. If they are, they can end up forming an effective cap on the supplier's liability for failure to provide services as a whole. And that cap may be lower than the general liability cap that's been carefully negotiated in the front end of the contract. As an exclusive remedy, they may also preclude the customer from terminating for material breach. So from the customer perspective, it's important to consider negotiating a concept such as critical service level failure, the level below which service credits cease to be an exclusive remedy, reserving those rights to claim damages and terminate. In the following slides, I've quoted some provisions of the government's model services contract just to indicate how service levels can be negotiated and defined. I'll move through these relatively quickly. The first one is an attempt at defining what available means in this concept. From the customer's perspective, it's just helpful to understand, obviously, the government's model services contract is drafted as relatively customer favouring. So it's helpful to recognise that this availability refers to all functions of the supplier system and the services, and also loops in performance against all of the KPIs. So after defining what available means, the SLA will typically then express the contractual targets by reference to an availability percentage. And the next slide shows a formula for calculating that percentage. I won't go into this in great detail, but what's relevant to note from it, of course, is that it's excluding omitted maintenance from the two sides of the calculation. So excluding permitted maintenance from the total minutes that could be available during the month, and also from the minutes of service downtime. So obviously, therefore, in negotiating how the availability percentage will be calculated, it's important to be clear about the impact of maintenance and the different types of maintenance on the score achieved by the supplier. And that's discussed in the wording on the next slide. So in this context, permitted maintenance is defined as a specific number of hours in a service period taking place at agreed times and days. As the clause on screen indicates, maintenance that exceeds that agreed number of hours, or which is not pre-planned, which would include any maintenance carried out outside the agreed maintenance windows, would accrue service points, and service points lead to service credits. So a key point for the customer to be alert to on this issue is the common attempt for the supplier to exclude from the calculation of service availability any downtime resulting from the requirement for emergency maintenance. As you can see on the model services formulation, that would not be excluded. But it's common in negotiations for the supplier to point out that they may need to take down a solution to avoid external threats or to address emergency scenarios. What's not so obvious is that that should necessarily be the customer's risk, as would be the case if any kind of emergency maintenance is automatically excluded from the calculation of uptime. Finally, before concluding my part of today's session, I'll look briefly at some of the negotiation points that arise when the proposed solution is an AI tool, or when the supply of the solution is based on the use of AI. So the involvement of artificial intelligence raises a range of considerations relevant to the contract, and some of these may be subject to negotiation. As discussed earlier, it remains important for the specification to be clear, which will include clarity over the role played by AI. Who's using it? Is it the customer who's using the AI solution, or the supplier? The contract should again be clear about customer dependencies, particularly in respect to what data sets need to be made available. The customer will need to undertake their own assessment of how security issues will be addressed, and will expect these to be supported by warranties from the supplier. They may want to see evidence of the supplier's security testing, for example. The customer should consider its own obligations in respect of confidentiality, as these relate to any information which it may make accessible to the AI system, or which it may generate. It will want the supplier to recognise that this information is confidential to the customer. And they may want the supplier to set out the technical measures which will be used to preserve that confidentiality. The customer will also need to assess its obligations as a controller of personal data and ensure that these are addressed in respect to any personal data that were processed using AI. This may involve internal measures, such as carrying out a data protection impact assessment, and also ensuring that the contract contains the appropriate clauses dealing with the relationship between customer and supplier. The legal interface between AI and intellectual property remains something of a grey area. That is, if you're being generous towards the creators of AI. But as between the customer and a specific supplier, the customer may want the contract expressly to prohibit infringement by the supplier of any IP-protected content of the customer. Going beyond that, the customer could seek an indemnity in respect of third-party claims for IP infringement arising from their use of the solution, but that might be very challenging for the supplier to give. In terms of scoping out what the solution will not do from the supplier's perspective, it will be important to set out any limitations or health warnings in respect of potential reliance on artificial intelligence. So if the solution involves the customer having access to the outputs of generative AI, the supplier may wish to flag the risk of bias, hallucination, or misinformation in the content generated. And finally, on AI, the customer may want the supplier to undertake that it has complied with current ethical standards relating to the use of AI in respect to matters such as transparency, fairness, contestability, and redress. So that brings my part of this morning's session to a conclusion. Obviously, only a snapshot, and we'll be happy to discuss any specific issues you have been encountering in practice. Thank you very much for listening. I'll now hand over to my colleague Richard Walsh, who will talk about issues arising in respect of insolvency, whether affecting your business or a counterparty.
Thank you, Richard. Well, my focus as part of this morning's live webinar will be on the importance of addressing issues of solvency and consequently potential and actual insolvency, whether it be in relation to your own client company or more often, hopefully, their customers and suppliers. Given the many challenges faced by the UK industry at the moment, it won't come as any surprise that the problems caused by a significantly rising number of corporate insolvencies in particular have become an increasingly common source of requests for advice and instructions from companies and their directors concerned about their own solvency. The legal concerns the potential insolvency scenarios raise will naturally therefore be of interest to in-house counsel, who will no doubt be seen by the board as the first line of defence in relation to tackling and addressing the problems encountered. I'll now consider briefly key areas of relevance, focusing first on your own company before going on to focus on their customers and suppliers. Sometimes the most difficult situation to deal with and face up to is the possibility of your own client company's solvency being in doubt, and where this is a real issue of concern, knowing how to tackle the problem. Well, in my experience, a lack of openness and the ability to address as quickly as possible the issues that have arisen are the biggest factors in failing to cope with the challenges caused by the risk of insolvency and therefore to preserve a company's solvency. We'll look more closely in a few minutes at the question of how to address customer and supplier solvency concerns and the fallout from their potential or actual insolvency. In the meantime, the fact that your clients' customers and suppliers are in financial difficulty can have a direct impact on your own client company's financial position, such as with the non-payment of invoices and the knock-on effect of failure to obtain key materials that are needed to produce products and render services. Identifying early signs of cash flow and liquidity problems will be crucial when seeking to avoid irreversible financial decline and terminal insolvency. Being able to satisfy yourself that the board, presumably led by the finance director, keeping a watchful eye on factors such as cash flow and working capital sufficiency, as well as the servicing of any bank loans or other lending, will be fundamental to your own peace of mind and ensuring that unwelcome problems, such as allegations of adverse conduct on the part of the directors, don't materialize further on down the line. From a practical perspective, any need for the restructuring of loans and the obtaining of any additional funding and finance to cope with cash flow and working capital requirements can only be identified at the appropriate time if adequate fiscal vigilance is there in place at all relevant times and where solvency is marginal or in serious doubt throughout the critical period. In sum, being able to demonstrate, should the company subsequently face a formal insolvency process, that careful attention was paid on an ongoing basis to the company's solvency whilst continuing to trade, will help to protect the personal position of directors when answering for their pre-insolvency conduct. Well, one common issue that I encounter when seeking to advise directors following their company's insolvency and when facing threat of director disqualification proceedings is the absence of sufficient record to explain key decision taking by the board of directors or to demonstrate that ongoing regard was had to the company's solvency. Without such written evidence, it will be more difficult for them to avoid allegations of wrongful trading and lack of fiscal responsibility. Evidence of proper minutes of meetings having been prepared and adequate financial data having been shared with all directors will help to counter any accusations of adverse conduct based on a lack of awareness of the company's position. A possible focus of attention for insolvency office holders, mainly liquidators and administrators, considering claims against directors, as well as a potential allegation from insolvency service investigators exploring the potential for director disqualification, is wrongful trading. Now, there's a link here to the issue of the sufficiency of information held by directors that I mentioned earlier. In summary, where there is at a time at which a company's directors knew or ought to have known that there was no reasonable prospect of avoiding insolvent liquidation, and yet they continue to trade and incur losses, they can be held liable for wrongful trading. If a wrongful trading claim is successfully brought by an insolvency office holder, this could result in the director who is found liable having to contribute to the assets of the company to make funds available for distributions to creditors. So from the point at which, say, administration or liquidation is a outcome, the so-called creditor duty arises. Well, this is referenced in section 172 of the Companies Act 2006 and was clarified in a 2022 Supreme Court decision referred to as the Sequana case. And this duty provides essentially that when that moment has come, then directors need to have the position of creditors uppermost in their mind and to ensure that all reasonable steps are taken to avoid losses to creditors. Well, you'll appreciate that another concern for the finance director may well be in ensuring that when cash flow doesn't permit all creditors to be paid on time, payments to those creditors whose products or services are deemed critical to the company's ability to continue to trade are prioritized. Well, whether companies ultimately unable to avoid a formal insolvency, the decision may well come back to haunt the finance director, as well for that matter as the other directors on the board for allowing those payments to be made. Where it becomes apparent that the company is in financial difficulty and there's a risk of certain creditors being preferred over other creditors, it's essential that the board considers the position carefully and seeks to avoid the possibility of a subsequent claim being brought against the directors for the making of such payments in the 6-month period prior to the company's insolvency, where payments are to unconnected third parties. The allegation of making or indeed allowing preferential payments can also be levelled against directors by the insolvency service in the context of establishing adverse conduct for the bringing of director disqualification proceedings. Well, there's one form of preference that does tend to incur the particular wrath of the Secretary of State for Business and Trade when considering the threat of director disqualification, and this is trading to the detriment of HMRC. This is where the payment of Crown liabilities such as VAT, PAYE and NIC is avoided and delayed, whilst at the same time debts to other creditors are settled. Not only does the detrimental treatment of HMRC in this increase the potential for a claim for preference against one or more directors, but also amounts to adverse conduct when looking to disqualify a director. Before going on to consider the impact of potential insolvency upon your client, companies, customers, and suppliers, it's probably worth looking briefly at a couple of potential options where there's the need to restructure and or compromise your client company's liabilities. Well, I'll look first of all very briefly at the company voluntary arrangement. This was introduced way back in the mid-1980s under the Insolvency Act, and the company voluntary arrangements, or CVA as it's more commonly known, is essentially a contract between the company and its creditors, and it's been used many times in the past as a means of compromising a company's unsecured debts such that they're paid over a long period of time, usually up to around 5 years. In addition, the CVA can result in part of the company's own liabilities being written off. So it's a really helpful tool to consolidate and compromise debt. The second option I want to discuss is much more recent in its conception. The Part 26A restructuring plan is now a part of the Companies Act 2006. It's largely based on the already existing scheme of arrangement, which was in place before, and it was brought into law as part of the Solvency and Governance Act 5 years ago in 2020. The idea being to allow distressed companies to restructure their debt whilst continuing to trade. They don't need to be insolvent to propose such a plan, but they often will be. A key feature of this plan, which sets it apart from the scheme for arrangements and which requires court involvement and creditor meetings to obtain their support and then a court sanction, is the concept of the cross-class cram-down. This effectively allows the court to sanction the plan even if some classes of creditors vote against it, so long as they're any worse off than they would be in a relevant alternative scenario, such as liquidation. Previously, the restructuring plan was only feasible for large companies with complex liabilities, due largely to the elaborate procedural steps required and also the significant costs involved. But a recent case, known as the distributed case, has now potentially opened up this restructuring tool for SMEs, especially where the makeup of the liability position is more straightforward and where HMRC liabilities may be a key component of the company's overall debts. I'll now turn to consider another key area of importance for your client company, namely trying to deal with the financial distress that can be faced by customers and suppliers. It goes without saying that the sooner the potential issues can be identified with customers and suppliers, the more likely it is that steps can be taken to minimize the impact of and fallout from potential insolvency of those companies. You should expect, of course, your finance director to be in control of managing credit terms to avoid overextension of trade credit that could leave your client company vulnerable where there's delayed or partial non-payment of invoices. But due to the period of credits given, it may take some time for this to hit home. Depending upon what your client company is saying where it sells goods, it may perhaps be feasible to take preventative measures to protect against a potential customer insolvency in the future, such as ensuring that retention of title clauses are incorporated into the terms of trade, which if effective may preserve your client company's ability in the event of a formal insolvency to recover goods not yet paid for. Finally, and where possible, you would want your client company to avoid over-reliance upon just one or two customers or, where relevant, suppliers, where such an over-reliance could become a significant issue when the relevant customer or supplier enters a formal insolvency process. Well, I've had a recent approach from a corporate client and their in-house counsel looking for advice in relation to what steps can be taken to protect, so far as possible, the company's position as a creditor in the event that the relevant customer ends up in a formal insolvency process, such as liquidation. The circumstances will, of course, differ from case to case, but any opportunity to bolster as a creditor through the taking of formal security, where a customer's assets are already encumbered, or to seek the support of a personal guarantee from one or more directors of the customer, backed by security over, say, residential property, should be considered where feasible. You may be approached by your client company in relation to having to consider what recovery action can be taken to protect your company's position as a creditor. Well, we've got significant experience of advising corporate clients on the appropriate legal steps to be taken when seeking to recover unpaid customer debts. On the assumption the amount that's owed by the customer is not the subject of a genuine dispute, then it may be appropriate to threaten winding up proceedings against the customer to force them, where possible, to repay the outstanding debt in full together with the costs involved in seeking the recovery. The ability, in most cases and where evidence permits, to issue a pre-petition letter providing, say, 72 or so of the intention to prepare and present a winding up petition can provide a cheap and effective means of flushing out the customer debtor to see if they're able to pay what they owe. It's not always possible to foresee the financial collapse of a key customer or supplier, and while steps can sometimes be taken to guard against or at least diminish the effects of a formal insolvency that's suffered by the company in question, on occasion, your client company will suddenly, and possibly without any notice, be faced with a scenario where a customer or supplier has fallen subject to a formal insolvency process. So I'll look at a few scenarios here, the first of which is administration. I suppose the key point to mention here is that depending on your status as a creditor, so whether you're secured or more likely unsecured, the options in terms of being able to force any meaningful steps to recover goods or obtain payment for unpaid invoices from a customer in administration are likely to be very limited due to the statutory moratorium that's in place once the administrator is appointed, and that prevents any legal processes being commenced or continued against the company and its assets. Well, it's fair to say that we're well positioned to provide specialist legal advice to creditor companies. This would often include scenarios where, for example, a landlord is considering their position in respect of tenants now in administration to see what they can do in relation to the recovery of pre-administration arrears of rent, and ensuring that the company in administration is occupying the property or properties for the benefit of the administration, and that rent is being paid on a timely basis. And in those scenarios, rent would be deemed to be an expense of the administration and therefore recoverable ahead of the administrator's fees. In addition, there may be the need to advise on the impacts of administration in relation to, say, supplier agreements, to assess the impact of the insolvency upon those contracts, and, for example, the ability of them to be assigned to a connected new co-purchaser out of administration as part of a prepackaged sale. Looking then at liquidation, well, should a customer or supplier have a winding up petition presented against them, advice may be required on how to respond to the petition. It may be appropriate for the petition to be supported by your client company. If the petitioning creditor then decides not to seek a winding up order at the hearing, possibly because of an offer from the debtor to repay their debt, then you may require advice on whether to seek carriage of the petition to advance your client company's own claim. Looking finally then at the CVA and Part 26 restructuring plan, you'll recall I mentioned these earlier in connection with your own client company's position if seeking to restructure or compromise its own liabilities. Well, there could be a need to consider equally to seek advice on your company's position and reaction to an engagement with a CVA or restructuring plan as a creditor, and to ensure that your client company's vote is used effectively and to secure the best possible outcome. I would say that in general, engagement as a creditor in relation to formal insolvency processes can be advantageous, whether as part of a creditors committee, say, to assist in or hold account an insolvency office holder in relation to the conduct of the insolvency process itself, or indeed as a creditor voting on, in the case of administration, the administrator's proposals in how he's conducting the administration process, or indeed in the case of administration or liquidation, to approve or reject the office holder's proposals for the basis and account of their fees. So finally then, summing up on what I've covered today, there are just a few key messages that you may want to take away. First of all, the importance of information and evidence. In dealing with potential insolvency and financial distress, it's essential to ensure that all of your client company's directors have access to the same level of information to enable sensible decisions to be taken, such as whether to continue to trade or what action, say, needs to be taken to safeguard the company's position as a creditor in a particular insolvency. Secondly, the importance of seeking early advice. Experience has shown that the earlier the directors of a company reach out for specialist advice, both from a lawyer or as appropriate from an insolvency practitioner, the more likely it is that the company will achieve a positive outcome, whether as a creditor or in fact as a debtor, and the more likely it is the directors may be able to avoid personal exposure to claims brought against them and to avoid disqualification as director, or alternatively to be able to, say, obtain leave to continue to act as a director of other companies. Their skills as a director are required and they have to continue managing those businesses. And finally, the importance of engagement as a creditor. Whilst there's no guarantee that your client company's position as a creditor will be influential to affect the outcome of a formal insolvency process and to enhance any return to creditors, it may be possible for it to have an impact on the final position and the level of distribution that is made to those creditors. Well, I do hope what you found, what I had to say, helpful, and appreciate you listening. Obviously, if you've got any particular issues or concerns that crop up, feel free to get in touch or have any queries, and we'll seek to assist. That brings me to the end of my part of today's webinar, and I'll now hand you over to Jonathan and Chris to talk about corporate governance.
Thanks, Richard. So I'm Jonathan, an associate in the corporate team, and today I'm going to talk about corporate governance especially for the in-house solicitor, as well as some recent updates to look out for. So what is corporate governance? Well, most of you will have quite a bit of awareness of this term, but to be clear, corporate governance is the system of rules, practices, and processes by which companies are directed and controlled. But I suppose the key issue is what this actually means in practice. So here are the key elements of corporate governance. Firstly, there's the board structure and duties, including roles, composition, and how responsibilities are allocated. I think it's just the next slide, if you can move that along. Risk management, secondly, so identifying, assessing, and managing financial, legal, reputational, and operational risks. Next, there's transparency and disclosure. So this is providing accurate, timely information to shareholders and stakeholders. Also, there's shareholder rights to consider. So these are the mechanisms that protect and empower shareholders, including voting and access to information. And lastly, there's corporate culture and ethics. So this can be setting the tone from the top to drive accountability, sustainability, and lawful behavior. Although governance isn't always the top of the corporate agenda, it matters. And here's why. Firstly, there's compliance. So ensuring adherence to laws, regulations, ethical standards, and helping reduce the risk of criminal or civil liability. Next, there's reputational. So well-governed companies are perceived as trustworthy, responsible, and credible, which matters to investors, regulators, and to customers. Then there's also investor confidence to consider. So good governance signals transparency and accountability, which in turn attracts and retains investment. And lastly, there's avoiding liability. A key thing is that poor governance can lead to costly failures, regulatory action, or personal liabilities for directors and officers. So what are the key roles and duties for in-house lawyers in governance? So in-house lawyers are essential in maintaining strong corporate governance. Your role extends far beyond compliance. You're an advisor, a risk manager, gatekeeper, an enabler of responsible business. But here's what that looks like in practice. So there's advising the board on directors' legal duties, so including fiduciary duties, the duty to promote the success of the company, avoid conflicts of interest, exercise care, skill, and diligence. So you help ensure that directors understand these obligations and act in a way that avoids personal or corporate liability. There's ensuring compliance with statutory obligations. So this includes managing companies' house filings, maintaining the statutory registers, confirmation statements, and any disclosure requirements that need to be made. This is important as later incorrect filings can result in fines, reputational harm, or further regulatory scrutiny. There's overseeing risk, preventing fraud, and supporting internal controls. So legal teams will work closely with the risk, audit, and compliance teams to ensure and mitigate legal and regulatory risks. This includes establishing or strengthening internal controls, fraud prevention procedures, and whistleblowing mechanisms. There's governance process integrity. So ensuring the board meetings are properly convened, minutes are accurately recorded, conflicts are declared and managed, and reporting obligations are met. In essence, keeping the company legally accountable and governance structures effective. There's acting as a bridge between business and regulation. So in-house lawyers translate complex legal requirements into practical risk-based advice that enables the business to operate effectively while staying compliant. The goal isn't to say no, but to guide the business to what can be considered as a compliant yes. But importantly, it's about sounding the alarm when needed. In-house solicitors play a vital role in raising red flags and escalating concerns to senior leadership, especially where there's non-compliance, there's serious risks, or misconduct has arisen. So this includes ensuring that businesses have safe mechanisms to escalate concerns and that people really do feel empowered to use them. So what's changing? There's major legislative and regulatory changes underway that will directly affect in-house teams and their governance responsibilities. Some of these are as follows. So firstly, the ECCTA, or the Economic Crime and Transparency Act 2023. So this is the most significant corporate law reform in a long time, but here are some of the key takeaways to consider. So firstly, there's the Companies House powers, which came in March 2024. Companies House have powers to query, reject, or remove incorrect filings, strike off dormant or false companies, and enforce more robust compliance. Companies must also ensure that they make active confirmations that they're carrying out lawful business. They've provided a registered email address, and they also adhere to the tightened registered office address rules. So this means that PO boxes are no longer acceptable. Addresses must allow for legal documents to actually reach someone who's acting on behalf of the company. Next up, there's identity verification. So this is coming into effect in autumn 2025, so very soon. This is mandatory for directors, PSCs, and those who are responsible for filing documentation. So existing directors and PSCs get a 12-month transitional period, but this can be completed through Companies House or authorised agents known as ACSPs. But it's important to note that these ID checks, if not completed, may prevent any Companies House filings from actually being accepted and lead to further sanctions. Then there's the failure to prevent fraud offence, which came in September 2025. This applies currently to large organisations, so over 250 employees, in excess of 36 million turnover, or 18 million worth of assets. So it's a criminal offence if fraud is committed by an employee or associated person of the company, and the company did not have reasonable prevention procedures in place. This is similar to the Bribery Act and the corporate criminal offence regime, but it shifts the burden onto companies to actively engage in preventing fraud. Then there's the corporate directors' restrictions to consider as well. Only UK registered corporate entities can act as corporate directors now, and only if all directors of the corporate entity are natural persons who have verified their identity. Ownership structures may need to be reviewed and updated before enforcement. And also a note that the enforcement tools of Companies House have been strengthened, so Companies House can now impose civil penalties, bring criminal proceedings, and share data with law enforcement. So I think on this point, we can expect more proactive enforcement and a focus on accuracy and transparency of data on the register. This brings on to the thought of transparency against privacy, and noting that it is a bit of a balancing act here. The trend obviously is towards greater corporate transparency, but we must note that this has to be balanced against privacy concerns, for example, public access to personal data like residential addresses, and obvious consideration of security risks, including increased potential for identity fraud where significant information is publicly available. Legal teams must help navigate this tension, especially when advising on filings and disclosures. So next up, there's the ESG reporting reforms. First, just touch on it's the Sustainability Reporting Standards, or the UK SRS. The UK is preparing to adopt the ISSB's aligned sustainability standards. So initially there's S1, which relates to general sustainability related disclosures. This covers broad ESG related disclosures and provides a framework for reporting on risks. Then there's S2, so this refers to climate related disclosures, which builds on the Task Force on Climate Related Financial Disclosures, or TCFD. These will eventually replace the TCFD framework for large UK companies. But what are the implications of adoption? So listed companies and large private companies are initially in scope of this, but it's likely to expand over time to cover further private companies and then even possibly SMEs. In-house counsel should actively prepare for more detailed and mandatory sustainability disclosures, linking ESG data to financial risk and reporting, independent assurance expectations for ESG metrics, and also to require a close board oversight on governance, with legal teams being key in advising on compliance risks and the accuracy of any disclosures that are required to be made. Then there's the Audit, Reporting and Governance Authority, or ARGA. So ARGA is the new UK regulator that's set to replace the FRC, or Financial Reporting Council, as part of broader reforms aimed at improving corporate governance, audit quality, and the financial reporting standards. So the key features of ARGA are greater powers over both listed companies, but also over large private companies. This broader scope means that companies and directors will be subject to stringent scrutiny. They can investigate, fine, and recommend disqualification for governance and reporting failures. They are focused on raising governance and audit standards, so they'll also address historic shortcomings in the UK's audit framework. And they'll play a central role generally in overseeing sustainability disclosures and assurance. Next up, there's the greenwashing crackdown. So here we can refer to the FCA's anti-greenwashing rules from May 2024. So the FCA introduced new rules aimed at cracking down greenwashing, which is the practice of making misleading or exaggerated ESG claims. This initiative is part of a wider effort to protect customers and investors, maintain market integrity, and ensure that sustainability-related disclosures are credible and transparent. This is to ensure that ESG-related claims are clear. So ESG claims should be expressed in a straightforward language that is easily understood and by its intended audience. It ensures that these claims must be fair, a true reflection of the product or service, not misleading, so they mustn't omit critical information that would affect the understanding of the claim, and claims must also be substantiated by robust, verifiable evidence. So here you'd need to demonstrate credible and up-to-date evidence based on reliable data sources, independent verification, or third-party certifications where relevant to back all of those ESG claims made. Next up, there's the CMA enforcement of consumer protection law. So the CMA, or the Competition and Markets Authority, plays a key role in protecting consumers from misleading environmental claims made by businesses. They can investigate vague or false green claims. For example, companies claiming to be climate neutral or eco-friendly that have been made without evidence. They'll also investigate any false assertions about the product's environmental benefits, or where claims have been made but omit information or can be seen to exaggerating sustainability potentials. Here, there's a risk of fines, brand damage, and enforcement notices. So what are some practical steps for in-house solicitors that can be taken right away? First up is to audit the company structure and governance. So review the group structure, the subsidiaries, and then the overseas or LLP entities. Confirm the PSC is correct and any director information is still accurate. Ensure upcoming identity verification obligations are understood and appropriately assigned. Another thing to do is to map governance and filing workflows. So confirm who handles filings and are they aware of all the updated requirements? Are external agents registered appropriately as ACSPs? And are internal systems ready for the new filing requirements? It's time to review and update internal policies. So in relation to fraud prevention even, are there reasonable procedures to meet the ECCTA's fraud offence standards? The filing protocols, is who signs off? Are these controls documented? And also measures in place for reporting and escalation. Is there a whistleblowing policy in place? And are concerns escalated and addressed appropriately? And then also is to consider engaging the board and executive team. So ensure that corporate governance risks are on the agenda, empower legal to advise and get on compliance needs early and not reactively. Also to secure resourcing and support for legal and governance teams and ensure mechanisms exist for raising concerns without the fear of retaliation. So to summary, corporate governance reform isn't just about compliance, it's about protecting the company, enabling growth and demonstrating accountability. The changes underway in the UK will significantly reshape the governance landscape, and in-house solicitors are at the heart of ensuring businesses are not just compliant, but also are transparent and responsible. I'll now hand over to Chris Moss, who will discuss regulated business and the FCA SYSC regime, as well as the UK Corporate Governance Code, the recent and upcoming changes, and finally, the proportionality of such control measures. Thank you.
Thanks, Jonathan. That's great. I'll make this a bit whistle stop because we've not got much time, but I thought there may be some help for people actually by starting with CISC. This will be familiar to anybody who is, pardon me, in a regulated business, but actually much of the toolkit that seems to be being implemented across various pieces of corporate governance now took root and started out with the FCA's regime in the wake of the financial crash. And the basic idea was that the FCA wants to make sure that senior managers are accountable and that firms proactively manage risk rather than simply being reactive or ticking boxes. Moving to the purpose of CISC, obviously reinforce senior management accountability, promote effective risk management, particularly clarify and allocate responsibilities and support compliance with the overall regime. That's really what the key bits of CISC in a corporate governance context are about. Moving on to a bit more granularity, key provisions. Next slide, please. The key parts of CISC are set out on this slide. I don't really need to go into it, but much. 4 to 10 covers the organisation, staff, compliance, risk, financial crime, risk control, onboarding. That's a big thing for the FCA at the moment. Record keeping and conflicts of interest, which is another biggie for them. Each of these areas are things that should be thematically identified in any good governance programme. Whistleblowing, that's been touched on before, and with ECTA, that's becoming more of a thing. CIS 19 in terms of remuneration, obviously that's particular to the financial services industry, but again, it's about aligning business interests with the remuneration that particularly senior managers are receiving. And 25 and 26 is about defining senior management roles, defining responsibilities, making them accountable, and making sure that continuity is preserved if roles have changed or if people move on. Recent emphasis, so PS 21.3, slightly old news now, but there is more focus on operational resilience. There's a lot of emphasis which is current on consumer duty integration into systems and controls within firms, and particularly now as well, the oversight of outsourcing and third-party risks. There's more of an emphasis on looking at that. I think they're sort of waking up a bit to that point. Moving on to something that is probably a bit more mainstream, which is the UK Corporate Governance Code. So what's this all about? Let's have a look at the key principles. So the code was updated 2024, and some of the changes came into force this year. But essentially, leadership and board effectiveness, making sure that responsibilities are divided so that no one individual dominates or there's no lack of balance, checks and balances. Remuneration, making sure that's appropriately looked at and assessed, risk management, internal controls. And you can see from the thrust of some of the things that Jonathan's talked about that more and more the emphasis is on processes, procedures, risk management. How can you be seen to be doing the right thing? How can you document and evidence your compliance so that if something comes down the track and does get to you, which is unexpected, you can turn around and say, look, we did everything we sensibly could. We were appropriately governed. Recent changes, So the recent rewrite or the recent updates emphasize the comply or explain approach to reporting, but also start to have more of an emphasis on proportionality, and I'll come on to that in just a second. The idea is to go through and look at enhanced risk and resilience reporting and greater transparency around board responsibilities generally. There is a nod, of course, more than a nod now to ESG and sustainability, and there's some updated guidance on board diversity and effectiveness in terms of understanding the company's culture, whether or not that culture supports the board's purpose, and how transparent it all is. Upcoming changes. So continued alignment with the ESG frameworks. Jonathan's touched on that. There's potential further strengthening of internal control regime reporting. That will be coming through in the next couple of years. And again, as Jonathan has adverted to in his talk, more granular focus will be coming through in terms of culture and values metrics. So we need to keep an eye on that in terms of the overall thrust of things. Proportionality next. What is it? Well, it does what it says on the tin, tailoring compliance and risk measures to the size complexity of the business, the risks that are faced, the sector, scale of operations, and the availability of resource. The idea behind it and why it matters is to avoid over-engineering of controls, to enable risk-based decision-making, and generally to look at risk in a smart way. This is the thrust of the changes. The regulatory expectation is that firms must be able to maintain and justify their governance approach. It's not enough to have fewer controls. You must demonstrate how your controls fit your risk profile and how they are effective in managing risk. And we come back to a common theme throughout Richard Wolf's talk and Jonathan's talk, which is about evidence and documentation. Increasingly, the burden of proof is shifted to customers, to individuals, to prove that they did things appropriately, as opposed to someone having to prove that they didn't. And in terms of the regulatory outlook, we can expect, I think, to see a lot more of the same, certainly over the next few years. I hope some of this has been helpful. And I think as the landscape develops, firms should proactively review governance, engage particularly with senior leadership, make sure that this comes from the top and that it's not just, as perhaps in the past it might have been a bit too much, a bit of a tick box exercise. You've got to live and breathe it really nowadays. Thank you for listening. I will hand back now to Akil to do some closing remarks.
Right, thank you all for joining online today. And to our speakers, hopefully there are some legal and practical tips, thoughts and takeaways for you all. Apologies for running over slightly, but there were certainly some really interesting insights on developments in AI, good and timely tips on managing customer and supplier solvency, and there was a nice reminder on various topics of compliance, especially with CISC and some of the ECTA changes around the corner. We'd also appreciate if you could take some time to fill out the feedback form, which will appear on your screen following the webinar, especially with any requests for future topics. Other than that, I really wish everybody a fantastic rest of your day. Thank you.